We have with us an esteemed panel, names which are synonymous with intellectual property law in Sri Lanka. We have Dr. Harsha Cabral, President's Counsel, Justice Dr. Ron Fernando, former judge of the Court of Appeal, and Professor Sampath Punchiheva, Dean of the Faculty of Law of the University of Colombo. For those who are not very familiar with intellectual property law, I thought a small introduction might be useful so that you could follow the more intricate details that are being presented to you. So, intellectual property law is the area of law that protects intellectual creations. And depending on the intellectual output, the type of law would differ. So, for example, if your output is a solution to a technical problem, it would be patent law. If your output is something creative, it would be copyright law. If your output is a sign that denotes quality or source, it would be trademark law. And in a lighter vein, if you don't know what your intellectual output is, you can try to rely on unfair competition or trade secrets. So, our first speaker would be Dr. Harsha Cabral, who will give a bird's eye view of the current intellectual property law landscape. And he would focus also on recent developments from a practitioner's perspective. Over to you, Dr. Cabral.
Thank you, Milhan. Good afternoon or good evening to everyone. Distinguished members of the head table, Justice Samyavardhana, I'm honored to have you here because now, though he sits in the Supreme Court, he was very one of the wonderful commercial high court judges we had. And from 1996, we have had commercial high court, and he has been one of the. There are a lot of judgments emanating from that era. And my good friend Sanat Veeratna, former public trustee, and I have a whole lot of some of my students and all friends who are here. So, without taking much time, I will. I was told that just to give a bird's eye view of intellectual property law. Well, intellectual property law is the law that one creates. Intellectual property is basically what you create with your intellect. That is called intellectual property. It's intangible property. You have tangible property, and intellectual property is intangible property which you create with your intellect. Now, that's why it's called in Sinhala, it's called Buddhimaya Depala. Buddhiya Yoda Tanagananada Depala. So the question can be, okay, if you don't have an intellect, can you create anything? You can. It's not the, because there will be people who can, create something with clay, right? Come up with a lovely article with clay. I mean, you don't need that amount of intellect for that, but that is your talent. So basically, intellectual property law is the law which the whole purpose of intellectual property law is how to get it, that is how to create it, how to keep it, and how to protect it. Those are the three main features of intellectual property law. How to get it? Well, we'll discuss as we go along. And then how do you keep it? Well, there are time durations. If it's a trademark, you can keep on registering as long as you want. But if it's a copyright, well, there are limitations, lifespan of the author, and 70 years thereafter. And in the same way, you have, say, if it's a patent, you have a monopoly for 20 years. Industrial design, it's 15 years, 5, 3 times you can register. So these are the limitations. How do you keep it? How do you protect this is now getting how to get it also, it's all there in our law. And how to protect this is where you go to court to get your injunctions, damages, so on and so forth. Now, intellectual property law falls into different heads. If you look at, as you know, this is another piece of law which came to us from the British Empire. It's English law that created intellectual property law. The known law on intellectual property law emanates from the British periods. So we, being a colony under the British, had the English statutes or the laws in place. And we had the Copyrights Act of 1911, Merchandise Marks Ordinance, Trademarks Ordinance. Whole lot of laws were in place until we started the open economy in the 70s. In 77, the new government came into operation, and the trade minister happened to be Mr. Lalit Tatulot who himself was a lawyer, and he wanted to bring all these intellectual property laws that were in different areas under one umbrella. So what he did was he got the assistance of the World Intellectual Property Organization, WIPO, and fortunately for us, WIPO was headed at that time by our very own Lakshman Kadrigam. So at that time, they were doing a model law for developing countries. And we were one of the first to get that model law for developing countries in the Asian region. And our law was Code of Intellectual Property Act number 52 of 1979. That is the very first time. So 77, the open economy, the new government came. From 78, the open economy started. 79, we had this law bringing all the separate copyright, industrial designs, patents, trademarks, unfair competition, all under one umbrella. So which brought in 52 of 1979, which is based on the WIPO model law. Now, this law was there in application for about 25 years. So during this 25-year period, there was another creation by the World Trade Organization, WTO, earlier known as GATT, General Agreement for Trade and Tariff, became WTO. And WTO, they wanted a model law for all the jurisdictions. They said, well, you can't have one type of law in India, one type of law in Sri Lanka, another type of law in Australia when it comes to intellectual property. So they wanted a uniform system of law. And they came up with the TRIPS agreement, Trade Related Intellectual Property Rights Agreement. And all the member states were given time to adjust their laws. India took about 4 extensions. We took about 5 extensions. And ultimately, we came up with this TRIPS formula of law in 2003. So the current act we have, Intellectual Property Act number 36 of 2003, is a TRIPS compliant law. It's a very modern law. So I must say that we have had it for a long time from 2003 onwards. It has 213 sections. It's a very, very composite piece of legislation. It has 213 sections, all departmentalized, crystal clear. From sections 5 to 27 deals with copyright. So there are only 22 sections with regard to copyright law. If you just master 22 sections, you master the law. There is no magic in that. Then from sections 28 to 61, you have industrial designs. The entire law of industrial designs is there. What is an industrial design? How to get it? How to keep it? Duration? How to assign it? License it? To nullify it? All that is there. Then from 62 to 100, you have the law of patents. What is a patent? What is patentability? What is innovation? What is prior art? All those are there. How to get it, how to keep it, duration, and nullify it, assigning it, all that is there. Then from 101, 62 to 100, you have that. From 101 onwards to 145, you have another important regime which deals with trademarks. Marks, trademarks, trade names, logos, all those come under that regime. From 146 to 159, you have the integrated circuits, ICs. Very few cases, there's only one case that has still come up. And then 160 is a very, very important section, which is known as unfair competition and undisclosed information. Large number of cases we do are based on unfair competition. Earlier, we used to call it passing off. And now you have undisclosed information. which is another area of trade secrets, which is we have a large number of cases. I think right now I must be uh, handling about over 20 cases on trade secrets. It's a very common thing. Now it's very easy to, take the whole company details in a little USB when you're leaving. That's why you have, your non-disclosure agreements and all that in your own organizations. Then 161 is also another nice piece of law which deals with geographical indications. What do you mean by Ceylon tea, Sri Lanka tea, Ceylon cinnamon? That's a geographical indication. Say Scotch whiskey has to come from Scotland. Rune Mikiri has to come from Rune and not from Batiklo. So that is geographical indications. Then 170 is a very crucial section. That is the civil remedies emanate from 170. All the practicing lawyers, that's bread and butter for us. That is under 170 only. You get your injunctions, damages, accounting of profits, and orders, so on and so forth. So that is with regard to the civil remedies. Then you have from 177 to 203 the criminal remedies, where you have to go to a magistrate court to get your search warrants, whatever. All those remedies are from that's all the criminal remedies. In addition, you have sections 206, 207, which deals with border control. Director General of Customs has been assigned with certain powers vis-a-vis exports and imports. So this is a composite piece of legislation which deals with the entirety of intellectual property law. That's why I say 213 sections. If you read it 3 times, you master it. You don't need, there is no magic in that. It's a very interesting thing, and it's a developing law. And very often, unlike in these property cases, these are protected for maybe prestige and so on and so forth. We have a lot of international players protecting their Coca-Cola or Apple or all these major trademarks. So they have to come to this particular jurisdiction to safeguard their rights. So intellectual property law is a very important piece of legislation for a country's development. Because if you don't have a proper law in place to protect your intellectual property creations, no investor will come into this country first. No one will want to invent if your neighbor is going to copy it. Sri Lanka is a country where we are full of copycats. Innovation is minimal, right? You are very good at copying. You have Odell, then you have M model, you have Orel, you have Opel. All these are cases in courts. All the practitioners know that these are these type of cases. You have the reported MTV cases. We have 3 good judgments from the Supreme Court, where MTV, Musical TV, that's a big company in the US. And then you have MTV, Maharaja TV. So day in, day out, we copy, we try to piggyback on somebody else's trade name or trademark. Trade name is protected in another way. Well, from the moment you create a company, you have a right. You don't have to register it as a trademark. Say if it's David Pierce Motor Company, that's your trade name. You can you can use DPMC. But if you want to have DPMC with a logo, circle or whatever, that becomes a trademark. So all these are the rights that, because sometimes these rights are so valuable. If you take the Coca-Cola mark, the trademark value is much bigger than their tangible assets. You put all your machinery, all your infrastructure, all the technical know-how, all that together, but the trademark right is, because you get the well-known marks in the world, under the Guinness Book of World Records, the most well-known mark is the cross. It's a mark, not a trademark, but a cross, well, emanating from Jesus Christ and the crucifixion. What do you think the most well-known mark number 2 is? Number 2 is Coca-Cola, right? So see the comparison, because the brand value. So there are so many well-known marks. in the world. There's a book called Butterworth's book of well-known marks. There are principles with regard to all that, how to get your registration, how to keep it, all that is set out in the law itself. But law is a very modern piece of legislation because it's on the TRIPS agreement and it deals with all the important areas. In most of the developed jurisdictions, more prominence is given to patents. We have it in sections 62 to 100. So patents are patent is the most important thing because the country can grow with the patent. If not for inventions, well, long years ago, the mobile phone was about this much. And now it's so tiny. Where is the aerial? Now in a car, where is the aerial? There's a little dot on your windshield. Sometimes these new cars are introduced. There are about 300, 400 patents involved. And people pay royalty. There are two major royalties that are paid to a Sri Lankan, Mr. Yadhigi. He's not making money from Mapico. It's from two patents where he gets royalty. Every time a car is manufactured, he gets 75% of 75 cents of a euro. That's a lot of money. And every 45 seconds, a car is manufactured. You see? So they use the content of that. So if you go to copyright, that's another separate regime itself. In intellectual property law, especially in copyright, you've got to keep in mind ideas are not protected. Expression of an idea is protected. Now, say if in my dream last night, if I see I'm flying over Colombo with some golden wings, like the Harry Potter stories, and I go over Shangri-La, the port city, and so on and so forth, and I wake up in the morning, I can remember this. Right. Some people can remember the dreams. Now, my second son has a lovely way of, he can continue the dream tomorrow, right? But say I get up in the morning, like I can remember what I saw. The golden wings, what I saw, ITC, Prathadeepa, Shangri-La, Golfes, Port City. But that's only an idea. But if I write a poem on that, that poem is protected. If I do a painting on that, what I saw, that is protected. So that's an expression of an idea. So that is how this law comes. So you can, do it in some, say if you look at Salalini Sandesha and all that, well, the Salalini are flying from Kotte to Kalania. Right. So that is what intellectual property is all about. When it's copyright, you have photography, you have sculpture, you have lecture. Even my lecture is protected. This what I say now is protected. Sometimes, when I lecture, these people come up with their dictaphones and with my permission, they record it. That's fine. But if someone, say, if all my students or one student records this and gets a script out of it and tries to sell it at 100 rupees a copy, then he is exploiting my rights, not otherwise. So there are limitations even in copyright. There are always limitations in all these rights that are given. So under all these regimes, even under copyright, there is now in copyright is not registrable in Sri Lanka. From the moment you do it, you have a right. But you have to establish that you have done it at a such and such a point. That's why in paintings you see George Keat, 1948, whatever date. Right. So that has to be emphasized that you have that copyright. Now, of course, when we write books, we put a copyright statement and I of course get the ISBN number so that it is recorded internationally that registration has been done that on such and such a date. Then in the same way, the rights are there. What are the rights? What can I do if someone copies my book? What do I do? It's a personal right. The best case I have come across on copyright law is the case between Da Vinci Code and Holy Blood and Holy Grail. The authors of Holy Blood and Holy Grail sued Da Vinci Code, saying that they have copied it. But a beautiful 56-page judgment, the English judge has said analyzing what character copying is, what theme copying is, what language copying is, and finally it comes to the conclusion that there is no substantive copying. You have to establish that there is substantive copying. The fact that Jesus Christ was born in Bethlehem, the mother was Virgin Mary, the father was a carpenter, the life of 33 years, all that is in the public domain. So they had to prove that what is not there in the public domain, new things. So we have a couple of important cases recorded in all these areas, whether it's copyright, designs, patents, trademarks, now so many on unfair competition, and a lot of criminal cases. All these reported cases from 1860 to 2021, I have done the volumes in 2 volumes. It's reported. All the cases are in 2 volumes. Whereas in India, you get thousands of cases. Now, actually, the third volume is coming out because from 21 to 2020 for 4 years, I've just got some enough cases for that. And third volume will be out very soon. So all the reported cases in Sri Lanka. In fact, the Clarence Vijayawardena case, I just got it a couple of 3-4 months back. Uh, it took 20 years, started in 2005 and finished it in 2000. Last Friday, I finished another case in the Supreme Court, and I told the bench that this is the 19th year. So we finished arguing it, and that's a 2-3 teachers writing a book, grade 7 book, and the written submissions are due in December, last working day. So the judgment will be next year. So again, another 20 years. There was another very interesting case where a writer called E.R. Eratna wrote a book called Romage Vasana. That was curriculum in the grade 7. And it was a adaptation from Charles Dickens' Great Expectations, based on Calania and all that. So there was a teledrama that was extracted out of this book, done by 3 university professors and a blue chip company sponsored. And we tried to stop it because it was 18 episodes. These people were so poor, and they asked for 18,000 rupees an episode. They were not given that. And we went to court. Unfortunately, it was an open and shut case, because if you stop 2 and they will immediately say, because even on the screen, it says, E.R. Eratna Suringe Romage Vasana Namati Puteng Uputagana Ladi. So it establishes my client's copyright, and the moral right is there. So we wanted the economic right. Sections 9 and 10 deal with economic right and moral right. So unfortunately, long years ago, it came up before Mr. Andrew Somavansa, who was a district judge at that time, long before the commercial high court was created. And he heard the case and said, well, anyway, you will get your damages at the end of the day. Why do you want to stop it? I am also watching that teledrama. So it took 11 years, mind you, to finally get it in the Supreme Court. And that also thanks to Justice Sarath Silva, who was Chief Justice, who was a very powerful man. He saw it. I mean, in 5 minutes, he picked up the point. He ordered the Rupavahini Corporation settle 500,000, and I'll give you 1 month. I can remember the day that lady brought the 500,000. This old lady took the check and ran out of court. Right. So most of these cases, I must say, talented people don't know their rights. So the idea of intellectual property is to make awareness. They should be aware of what their rights are and why you should protect them. If you don't protect them, it's free for all. If it's a private right. If you don't want to protect your right, state is not going to protect your right. So the development of a country depends on this. How your laws are in place, how intellectual properties laws are in place. Now, long years ago, you can walk into a Sibling Tower in Singapore and pick up cheap software, $5, $6, all duplicate counterfeit software. Now you can't get it. So the laws are in place. So I hope and pray in this jurisdiction also that will work. All your civil remedies have to be in the commercial high court, and one stop shop to the Supreme Court. So it's short, it works well. It's one law that has worked well. The other place is the criminal matters. You have to go to the magistrate court of the area. They have jurisdiction. Then, if it's a customs matter, you go to the Director General of Customs. That those are the enforcement of three enforcement agencies that will cover intellectual property. In addition, you have the Director General of Intellectual Property, who will assist you with regard to getting your registrations, cancellations, so on and so forth. So copyright, there is no registration. Industrial design, it's a must. If you don't have a registration, you have no protection for 15 years. Patents, you got to register, then you have a monopoly for 20 years. Trademarks, it's up to you to extend it as long as the company is there in operation. So there are limitations with this. Ultimately, the law is how to get it, how to keep it, and how to protect it. So if there is a proper law in place, that is a plus point for development of any jurisdiction. And Sri Lanka, we have this place, have this law in place. That is one plus point we have vis-a-vis investment attraction. So the individuals also, it's a nice law for young lawyers to get into, because your clients are sometimes commercial minded, so they have to protect their trademarks. And well, if you get an opportunity of defending uh, say looking after the rights of a multinational company, well, sky is the limit for your charges. So they have international charges. So there is a lot of scope with regard to registration of trademarks, a lot of work in the intellectual property office, international registrations, international operations of patents, so on and so forth. So I would advise the younger generation lawyers to put more emphasis on this particular area of the law. And studying the law is so simple because this has only 213 sections. If you want to master it, you can read it two times, three times. And then if you want to read the case law, well, now the books are there. You can look at the cases. And Justice Ruan Fernando is also in the process of getting the commercial high court cases printed. So there's a lot of material and there is enough literature on this particular subject, but you got to take a liking to the subject. So I hope the younger generation lawyers will take it to a different level. And this is a law that has helped a country to go forward. And it will be more important and effective if newer laws borderline, which borderlines with this also are supportive. And I would I would appeal from the Supreme Court to give us more judgments on these areas. There are lots and lots of judgments on fundamental rights, but on intellectual property, the judgments are very few. So I would appeal to the Supreme Court judge who is present here to uh, take note of that and to give us some more judgments so that even for the education purposes, that will be helpful. Thank you very much.
So, as Dr. Cabral said, our current Intellectual Property Act is based on the TRIPS agreement, which has its own history in the multilateral negotiations. You may know that it was imposed on developing countries, so to say, by the developed world, on the promise that there'll be technology transfer. And whether that has actually happened is a matter that we can discuss after we finish. Our next speaker for today is Justice Dr. Juan Fernando, who will speak of AI and the protection and enforcement of intellectual property.
Intellectual property. The argument or the debate today is that the AI should be protected under the intellectual property regime. My argument is that we have completely forgotten the other side of the IP and the AI, so that there is a need to consider the value, the role of AI evidence in protecting intellectual property. We have not, we have completely forgot about that aspect, so that AI is reshaping the navigation of the IP and the IP litigation in particular. AI is transforming as to how the IP right should be protected and how the IP infringement should be detected, so that as the AI now enters the courtroom, the lawyers and the judges face challenges in the area of authenticity, reliability, admissibility, explainability of AI evidence. So we have to look at as to how the uh, the positive side of AI should be used by uh, IP lawyers in order to protect IP and as well as to detect IP infringement. So, first of all, if we look at the current debate as to whether AI can be the author, we have cases. First case is Naruto, where the argument was that uh, mm, uh, monkey, not a human, cannot be the author. So that there is no dispute now that monkey cannot be the author, because copyright protects provide protection for the human author. So then case law developed thereafter, the Taylor case, famous case where the Debus system or a machine was claimed to be the copyright author, and that argument was rejected by the US Supreme Court because a machine, not a human author, can't be considered as the author. Then came the third case, also the Taylor case in the UK, where the Debus machine was claimed to be the inventor, and the UK District Court, Court of Appeal, and ultimately the recently in May, the Supreme Court of UK rejected the case, the claim that a Debus machine can be the author. So there is no dispute now. Only the human authorship or human inventorship can be protected under the current AI regime. So that, but we have completely forgot about the positive side of AI evidence. AI can be the creative tool. AI can be the inventive tool. AI can be used to detect IP infringement, and especially AI evidence can be very, very useful both for the protection of intellectual property as well as the detection of IP infringement. So types of AI evidence, you will see that there are so many aspects of AI evidence which we have forgotten. For example, authorship and ownership verification data, then the originality and similarity analysis report and the data, uh, and copyright metadata, chain of custody verification data, then the patent prior art technical comparison data or report. Uh, so there are so many type of AI data that can be used not only for the protection of IP authors and the inventors, but also to detect when there is an infringement. So, what is AI evidence? What is electronic evidence? There is a similarity. Electronic evidence is a data or information that is created or stored or that is transmitted or that is communicated in electronic form and found in electronic devices and electronic system. Now, when it comes to the AI evidence, which is relevant to the IP litigation, is also the information, data, or outputs uh, generated rather than creation. It is generated by AI systems, so that which is presented to court either to prove IP rights or to detect infringement. So we have two type of AI evidence. One is evidence in respect of AI's assisted evidence and the AI generated evidence that is very useful for IP infringement cases and for the protection of AI in court litigation. So look at this photo and these two photos. Can you see which is real? Hardly very difficult. Now this flower, can you say which is real and which is AI generated? Perhaps the left side is the real photo, right side is the AI generated. Below that, the first one is, this is the real one, other one is the AI generated, but difficult to say in a litigation. So that is why AI evidence will be helpful to detect, not only prove, but even to detect infringement. Now take for example this rose flower. Left side is the real one, right side is the AI generated rose. So by looking at that, nobody can say in a litigation what is real and what is generated one. So you need evidence, you need technical evidence. So that is why the AI evidence in IP litigation is very, very crucial. So now the left side is the AI assisted work. There's an artwork, but it is not AI generated, but this is a AI assisted artwork. A recent case filed in the US. This photograph or the artwork was claimed by a gentleman called Alan, who claimed to be the author, which was created by AI tool called Midjourney. But Alan was held to be the author on the ground that he has used a human contribution. Look at the right side one. That is a AI generated design. Left side is a AI assisted work with the human authorship. Right side is purely AI generated one where there is no human authorship. So the real debate in this in this world is not whether AI can be the author or AI can be the inventor, but whether AI is whether there is a AI assisted work or AI generated work. That is the current debate. If you look at the litigation uh, in the world, so what is this difference? What is AI assisted and what is AI generated? What is the difference? Look at the left side is a AI assisted work with human creativity. Right side is AI generated one. What is the difference? In the AI assisted, you need evidence that there was human contribution. There must be substantial human contribution. Unless there is a substantial human contribution, uh, you can't claim uh, copyright or inventorship for AI assisted work. So the AI assisted work is basically work developed by human. There must be human contribution, but assisted by AI tools. So the AI is being used as a tool, not as the author or an inventor. So in case of AI assisted invention or work, work is developed by the human, but with the assistance of AI tool. In the case of AI generated, there is no human contribution whatsoever. AI is a machine which is developing independently of by the AI system. So that's the difference. So the main difference is in case of AI system, there must be a human contribution, whereas AI generated, there is no human contribution. Second one is the control. The human must control the whole system, not only the AI tools, but the whole entire process. For example, though the content is generated by a tool like ChatGPT, the human will manage, control, decide the editing part, the modification, alteration, final creativity, or final inventorship, so that the human is in the control of the whole process. If that is so, it is a AI assisted work. Whereas in the case of AI generated, there is no human assisted. The 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 prompt is given to the chat GPT. Chat GPT creates everything. The final output belongs to the is created by the chat GPT. There is no human involvement. There is no human contribution. So that is AI generated. You can't protect AI generated work because there is no human authorship. There is no human inventorship. So that in case of AI assisted, human can claim either copyright or patent protection, provided there is a human contribution, which will be compatible with the threshold requirement of creativity in case of copyright or inventorship in case of patent. If that is so, AI assisted work will be protected. Whereas in case of AI generated, there is no human contribution, so it will not be protected. That is why this most of the cases in US and UK, the claim that the AI machine should be regarded as author or an inventor has been rejected. So now the classic example would be this. Now here the first photograph we see Alan writes a novel about the futuristic dinosaur world. He is using ChatGPT as a creative assistant. He's using ChatGPT as a tool and requesting ChatGPT not to write the novel, but he's requesting the ChatGPT to brainstorm ideas, get the ideas, suggestions, and say the plot points and characters. But having got the generated content from the ChatGPT, he's modifying, he's recreating, he's redesigning, he's modifying, and the complete output belongs to Alan, not to the ChatGPT. The first one, Alan can claim authorship. Look at the second one, Johnson. He prompts ChatGPT to write or generate a complete, full-length novel on the same futuristic dinosaur world. And ChatGPT generate the full content. There is no any human contribution by Alan Johnson. So that it is a purely AI generated. Now here this is the there is no final output is also belongs to the ChatGPT. So this is a AI generated, no protection. First part, final output belongs to Alan, so that Alan has modified, Alan has control, he is making the decision, he is altering the content generated by ChatGPT, so he can claim, he may claim copyright protection. So that third one is a situation where uh, a designer using AI tool called Midjourney to generate a logo concept, not a really logo, but he's asking, giving a prompt to Midjourney to develop a concept on a design called a new cat for the business. So the ChatGPT the Midjourney tool will only create a concept of a new cat. But thereafter, designer will rework that. He will redesign. He will also recreate the final logo. So that this is the Midjourney concept. So many cats. Midjourney will create, say, 5, 6, 5, 7, 8, 9, 10. So the designer will select one of them, he will modify, he will redesign, he will recreate, he will alter, and he will create the final output. Food, so that final output belongs to the designer, so that he may claim rights to the final output. But the second case is a situation where the designer is using AI tool called this AI art generator or AI graphic generator to generate the full logo, and thereafter the AI tool generate the full logo. There is no human invention, human intervention. There is no human contribution. So that is a completely AI generated, so no protection. Now, what is the nature of the human contribution that is required in a IP litigation, either to prove that his output is AI assisted, not AI generated. Now, those are the factors that will be useful. First of all, there must be evidence of human creativity. That's the main thing. And also the editorial control. The editor who is editing using rewriting, recreating, then that is evidence of editorial control. And also he is making his own direction. He's not relying on the ChatGPT direction or content. He's redirecting. He's making his own judgment. Then it will be the evidence of significant human contribution, a substantial human contribution. Then only human can claim either the authorship or the inventorship. So, AI evidence can be used to establish originality. Like this, this is a AI assisted artwork. If there is threshold human contribution with the decision making control used by a human author, then of course it may be possible for him to claim authorship. And this is the AI assisted creativity, art, not the AI generated one. Now, here, if the author can show that he is in control, he didn't rely on the ChatGPT content, but having got the content by ChatGPT, he modified, he rewrote or redesigned, and final output was his. Then it may be possible for him to claim authorship or subsequent ownership of the work. Now, this is a AI assisted patent application filed in the US courts where the if it's still pending, if the claimant can show that this is a human inventorship, and also this is a patentable invention, which is basically there is a novelty and inventive step with inventive concept, he has made a substantial development to the technology, which is different from what is in the existing in the public domain. Perhaps he may be able to claim patent protection or AI assisted. So the principle is it is the AI assisted, whether it is creativity or invention, that can be protected, not purely AI generated one. So that this difference will show how to identify in case of AI authorship. What are the requirements that should be satisfied? For example, human contribution, creative concept, technical contribution by the historical evidence, and metadata is one of the important part of the evidence. It applies both to electronic evidence and the AI evidence. And most importantly, the human judgment and reasoning. So that if that is so, it may be possible. Now, this is very important recent case, Allen versus US Copyright Office case, where the Allen is artist who used the Midjourney AI tool to get certain contents, and he got 600 contents, and thereafter he modified it, he recreated by using his own human contribution. So the court held, if you are to claim your copyright protection for AI assisted invention, AI assisted creativity, there are two tests must be satisfied. Number one is the machine must have conceived of the authorship. If the machine has conceived authorship, then of course you can't claim any right because it is a creation of the machine. On the other hand, if the machine has executed the final output, then again you can't claim any protection. But on the other hand, if it is the human contribution which has created the final output, it may be possible. So this is, of course, is a AI generated creativity, and Allen was held to be the author because of the human contribution made by him, which is completely different from what was created by by Midjourney. That's also the AI tool. So that if we are to find evidence, present evidence in a court of law, in IP litigation, what do we want? What is the type of evidence? So where do you find this evidence? Evidence will be, you can find this in AI system, logs, ChatGPT, Grammarly, and various other AI tools. You can use it. And there will be user devices. For example, edits made by the author, his version history that he is involved in the entire process, that he has given direction to ChatGPT, for example, to create, and he has made several editorials, he has changed, altered, uh, and that is his final product. So the user devices will be one of the places where the AI evidence can be found. Then the training database, the training data sets, like this video, audio, and text, all these things are found in the AI devices, and the metadata importantly. Then, uh, f- then a final one is, right, you have collected evidence, you have to present. You have to present what are the factors. Evidence must be relevant. There must be authentication. Evidence must be authenticated. It must be admissibility and explainability. You must explain by expert. So the most important test are, there must be evidence of testability, uh, and peer review and publication, whether it has been peer reviewed, and whether there is an error, standard of control, and the general acceptance. So those are the factors that must be satisfied in the case of AI evidence that has to be placed before a court of law. So those are the factors that will be useful in establishing evidence in a case of AI assisted, whether it is AI assisted creative work or AI assisted.
Thank you, Justice Fernando. Um, so now you know, if you upload a picture of you on ChatGPT and ask it to make you look like Julius Caesar or Cleopatra, you won't own copyright over that. So now I invite the last speaker for the day, Professor Punchiheva, who will speak about how important the protection of intellectual property is for economic development. And I know he has a soft spot for tourism-related intellectual property rights, which I'm sure he will also focus on. And the floor is yours, Dr. Punchiheva.
Thank you very much. Good evening, ladies and gentlemen. It's my honor, His Lordship, um, Honorable Justice Mahinda Samyavardhana sir is here. So I'm greatly honored to make this presentation, and also the gurus in IP world of IP in Sri Lanka are also present. So my all some of you are colleagues, and some of you are also I have met. In different forums. So today I thought of taking you through the importance of intellectual property rights for economic development, as my previous speakers laid a very strong foundation for you to digest the concept of intellectual property. But I think it is very important in the years to come, because being lawyers and the members of the legal fraternity, you should know this subject very clearly, because the world is moving towards the AI driven world and this technology driven world. And without IP, ICT, no lawyer in another 10, 15 years to survive, because it is so important that today even the answers in court proceedings being tailored by using ChatGPT, and always been very much found detected in some jurisdictions like in the United States and Singapore. I think you will have a lot of issues. So today, this topic, I wanted to start with the importance of intellectual property for the development of the country. So intellectual property rights are important because it is the building block of any innovation system. So intellectual property means the creations of the human mind, finest creations of the human mind. මිනිස් මනසේ අග්‍රගන්‍ය නිර්මාණයන් ආරක්ෂා කිරීමට අපි කියනවා, ආරක්ෂා කරන සංකල්පයට කියනවා intellectual property. The law that protects the finest creations of the human mind is the intellectual property law. So in Sri Lanka, as Dr. Cabral sir rightly pointed out, the intellectual property legal landscape is made of the Intellectual Property Act number 36 of 2003 and the case law jurisprudence handed down by the Sri Lankan courts and also some other countries to as a point of reference. So recently, as you might enjoy reading, there was a case in the Supreme Court. The decision was handed down by the Supreme Court in the case of the Sarasavi publishers versus Samaranayaka. This case, where Cook, publish Silvas, Hela Ratavata, Yumpio, the book was in dispute. Unfortunately, the decision was that he owned the Mr. Public Silva owns the copyright. But I had my own critique, because I don't believe that, because the author, was an illiterate. He could not write, and that brings us to the question that Honorable Justice Dr. Juan Fernando said: who holds the test is who holds the creative control of the expression. So, but unfortunately, that argument was not brought from the initial level, and that was if I step shoes of a critique, I would decide otherwise, because the Sudharma Samaranayaka, who listened to this Pabili Silva, who said recipes and things, and she used her talents to write this book, and who also should be given some rights. If I were to decide that, I would say the argument has come from legal fraternity. There should be the argument for co-authorship. Co-authorship should be brought in, because otherwise Sudharma Samaranayaka would not have get any rights. Who wrote the book? But on the surface, the presumption was the whose name was written on the surface, on the cover, is attributed to Pabili Silva. So this case is an eye opener for us, And being the members of the legal fraternity, you should be, you should deepen your understanding about intellectual property rights. As Cabral sir rightly pointed out, there are many cases, and there will be more and more cases surfacing in the legal landscape of Sri Lanka. So intellectual property, as already spoken about, is divided into two main branches: copyright and industrial property. So copyright protects the creative expression. So if you sing a song, there are many cases. uh, y- Take the example of a song as two copyright owners, who writes the word lyrics, and the other one who composes, the who writes the words, lyricist, and also music composer. And the singer will have neighboring rights. There's a big debate today, and also that has been taken into political stages also, arguing the artists, the performers, singers are asking, we too need third category of copyright. But of course, internationally, third category is the neighboring rights. Neighboring rights is, there is not the same level. It is given second level. The one who brings the work to the public with some beautification, with talents, they are given. Clarence, but you are a very good fan of Clarence. Clarence was an extraordinary person, and he composed certain things. But of course, today there's a, for, pardon me for saying, there's a song, Borolu and in a Payat Nindavana, that Deepika Priyadarshani was complaining, crying that I was not allowed to sing this song because Dr. Rohana Veerasinghe did not allow her to sing the song. So there are many issues today uh, uh, cropping up in courts. So I just wanted to alert you to this issue. And also, Sri Lanka has not tapped the potential of intellectual property rights in last 78 years since independence. But we are not a nation of that sort. In 140 BC, it is we built nine-storied Loha Mahapaya. This nine-storied building, and it was visible in the Indian Ocean, as in Chinese historian wrote. Are we a backward nation? But how many patents do we have? Less than 200 granted. We are, in that sense, we are very poor, but we are not a poor nation. We are the nation, even in the time before the Jesus Christ was born. We are the nations. We are a nation who built enormous innovation. But up today, we have become a very dependent nation because we have not created adequate intellectual property in our country. So we have less patents. We have less designs. So any even if you take mobile phone, the outer appearance is look and feel elements and protected by design rights. Interior technical solutions are protected by patents. So likewise, how many patents, how many designs in this software? Software is partly protected by copyright, partly protected by patents. Also, trade secrets. Interoperability codes are trade secrets. So, in one item of day life, so many IP rights giving complementary protection. So, I think IP is a world, it's a fascinating topic that we all should think about. And my learned friend wanted me to touch a bit of now, just for one thing, creative expression, right? As Harsha sir rightly pointed out, I write about Sigiriya. The In 5th century AD, King Kashyap's son, King Dhatusena's son, Kashyapa built Sigiriya, and that is Mahavansa says that. But I write in that when Harsha sir writes, Sigiriya was built by uh, uh, King Kashyapa, who killed his father. Like, but my expression is different from Sir's expression, because copyright protects the expression, not the idea. Expression. Expression means the way that I arrange my words. So expression is protected. And that the expression has a value. Even Candian dance, expression, the way that you perform, is an expression. How you express is the expression that protected. To extract the value of that expression, you need the device called copyright. Likewise, we have patents, trademark. Trademark is a sign that distinguishes products of one enterprise from that of another. Everyone needs it. Otherwise, how can you show your products to the world? And now, today, you need to register um, domain names, your internet address to the business. Otherwise, you will not be visible by the customers. Even hotel industry should promote through websites. So you need domain name. You have to register. Otherwise, somebody else will catch your domain because it is operated under the principle press come press serve. So then later on, even Madonna had her name all taken away by somebody else for some obscene things. And anyway, she got it back saying, I have the legitimate interest. Nobody else has legitimate interest like me. Likewise, you need to register. Trademark is a service mark, is even this hotel, yeah, is a brand. Brand is the proposition. Brand is a broader thing, includes goodwill, advertising, and brand is protected to trademark. So you need to protect your trademarks. And then you need GIs. GIs are the product linked to the place. Origin link products. Ceylon's tea, the best brand. Uh, GI, geographical indication. Ceylon cinnamon. Best cinnamon is coming from Sri Lanka. The other cinnamons having larger quantity of coumarin. Coumarin is a substance that would cause bowel ulcer. But Ceylon cinnamon has the best, the lowest quantity of that ingredients. Those who have done science might know. And Ceylon cinnamon, internationally, cassia means the cinnamons coming from other regions are marketed as Ceylon cinnamon. So Sri Lankan geographical indications are of enormous value in the world market, but Ceylon tea, Ceylon cinnamon being abused, misappropriated by other countries. So Madagascar tea is blended and sold as Ceylon cinnamon. I have, when I was in Munich, I saw Assam cinnamon, so Assam Ceylon and Lloyd Ceylon. And there the Ceylon's tea brand is very much abused. So I think we are sitting on a gold mine, untapped gold mine. That is why Sri Lanka has become IP importing country as opposed to IP exporting country. Country cannot go like this. We have to awaken the interest of intellectual property, create intellectual property in order to promote the economy on in the country. Even in the tourism sector, we must pay keen attention to brand, promotion of brand, and promote Sri Lankan products through authentic uh, certification marks, GI, geographical indications, and also trade secrets. Now, Coca-Cola has the long history of trade secret, and it has been kept jealously guarded in the United States more than 200 years. So Coca-Cola recipe is a top trade secret. Then two managers who know the secret cannot fly on board of a plane at one time. So like Siddhalepa, so the trade secret, nobody knows the recipe. And Samahan, nobody knows the recipe, the boiling protocols. So even there are many trade secrets in our country. Even Vedamahatya would have trade secrets and should protect. The trade secrets have value, and we should tap this untapped potential. We should realize the potential of Sri Lankan intellectual property. And also, in the years to come, we should try to bring intellectual property regime also modernize, because already it was said that Intellectual Property Act was enacted in 2003. Now we have almost 20 years passed, and we need to modernize. One example is we need to bring our law on par with at least the WIPO internet treaties. Otherwise, we will be having issues. But we need to identify because most of the content online will have some consequences if we do not enter into legal reform. And Sri Lanka, uh, as you learn in the morning, law alone will not take you to that distance. We need to develop institutional capacity, awareness, and also learning lessons from other countries. And most of the my one of the arguments I made in recent time is that Sri Lanka should also promote small patent system to cater for the needs of the small time invention, grassroots innovation, because not everyone has the technological height to obtain patent rights. Then we should have highways for uh, big companies and other roads for other innovations. Otherwise, it is discriminatory. Law is discriminatory towards the homegrown creativity, because one author in the West has seen Sri Lanka. There is a in Sri Lanka there is a shortage of homegrown creativity. I think we should promote homegrown creativity in this country. As some time ago, um, Kumartunga Munidasa said that the nation that does not invent new things cannot rise in this competitive world. Alut talut dan notanana jatiya lova nonagenne. I think that is a very motto. This is a visionary statement for us in going forward. I think I have noted down certain things, but I wanted to tell these things to you in order to. Also, I must tell economic understanding of intellectual property. Intellectual property rights are considered as hopes, prospects. In theory, in the Sir Edmund Keith's theory states that an IP right is giving hopes. When you have IP right, you will be given hope that in your mind, that's called psychological advantage, that my competitors will be delayed for 20 years to market with regard to patent. So I will be able to take the advantage, lead time advantage with regard to take, for example, pharmaceutical product. So you will be given time for to regain your uh, investment. So intellectual property rights are protected to incentivize, to motivate innovation and creations. There are two areas: innovations, creations. Creations are protected by copyright and neighboring rights. Innovations are protected by industrial property, patents, design right, trade secret, trademark, geographical indication, and other the property rights, assets, intellectual property assets in the field of industrial property. So these are the main things I wanted to tell. So there are two theories basically underpinning intellectual property rights. First one, incentive theory, giving motivation, incentivizing innovation and creations. Other one, prospect theory. Prospect means hopes. If you have an IP right, piece of IP right, that will give you the hopes to make profits. To you will have a psychological advantage that my competitors will be delayed, so I will be investing in intellectual property rights. So Sri Lanka has to promote intellectual property rights in order to go forward. In particular, we need entire music industry, entire creative industries are very much dependent on copyright and industrial innovation, and other promotion of innovation can be boosted by patent system. And agricultural products like Ceylon tea, Ceylon cinnamon can be promoted by geographical indications, and Hela Vedakama and other traditional system of knowledge can be also protected by trade secrets. And many other things will emerge in the future, like AI, as Honorable Justice Dr. Juan Fernando rightly pointed out. AI will give you a lot of challenges in the years to come. Then the test is who holds the creative control of that. AI assisted IP will be protected. We have to think about it. And AI generated may not have protection. This is a global hot topic today, but of course we have to find solution in our jurisdiction as well. So time is over. Thank you so much.